Hey, folks, next up on This Week in Law, we've got Bryce Knight from Invent joining us. We're going to talk about lots of legal issues confronting startups, including their funding and their communications. Jammie Thomas is trying to head for the Supreme Court. Latest in Viacom versus YouTube, Apple versus Samsung. Is anyone up? All that and more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell and Evan Brown. Episode 191, recorded December 14, 2012. Trolls, Trust, Selfies, and Sundays. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow. Send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter TWiL. Hello, I'm Denise Howell, and you're joining us for This Week in Law. We're going to have, hopefully, an insightful and interesting discussion on the latest and greatest in technology law stories. Joining us today from invent.vc is Bryce Knight. Hello, Bryce.
Hi, Denise. How are you?
I'm great. It's wonderful to have you on the show. We understand you're not feeling 100% today, so we're really thrilled that you're powering through and joining us anyway. We greatly appreciate it.
Absolutely. Thank you for having me.
Our pleasure. And also here with us is my co-host, Evan Brown from Chicago, Illinois. Hello, Evan.
Hey, Denise. How are things in California today?
Things in California are good. And both Bryce and I are in that general neck of the world of Southern California. Evan's in Chicago, and we understand that this morning, for anyone who's watching us live, that we're just want to let you know that our hearts are going out to everyone in Newtown, Connecticut, and across the country who are paying attention to the unfolding events there. And it's just, awful and tragic. And in fact, we had Jason Rantanen scheduled to join us today, a patent law professor and intellectual property law professor in Iowa, who is, just a bit too derailed by all of this to think about talking about technology law for the duration of our show right now. And I can't really blame him. It's a terrible thing that's happening across the country with these shootings cropping up in now in elementary school in Newtown, Connecticut. So we are going to do our best to get past that and talk about the stories that we had lined up for today, but it's definitely hard to focus. Evan and I both have little kids. Jason, you look like maybe you're a bit too young to be there yet, although I'm not sure. Are you a parent?
No kids yet for me.
No kids yet for you. So definitely it rocks your world as a parent to hear that something like this has occurred.
I'm sure. What's the actual story? What happened?
Well, I think it's still unfolding. I'm getting conflicting reports from CNN and USA Today as to how many people are dead. CNN says nearly 20 with 10 children. Oh, no, I just refreshed. Close to 30, mostly children. Just awful.
Who was the shooter,
Again, I think it's too early to say, and they're getting conflicting reports. I saw, an unconfirmed, this is leaked from, anonymous source in the investigation said they thought perhaps it was the father of one of the children at the school. And I think we just have to wait on this. It's all too soon. It just happened, I think, at 10:30 Eastern time this morning. And the other thing I'm seeing is whether or not there was one shooter or two shooter. I think they have said the primary shooter, or at least somebody, is dead at the scene, and I think they had someone else in custody. So, I hesitate to try and pin down any of these details at this juncture, because it looks like, on CNN and CBS News, the story's changing on literally every 5 to 10 minute basis.
You're just reading what you're seeing, certainly not close to doing any independent reporting here.
Oh, no, absolutely not. I am sitting here refreshing web pages. So.
Kind of in Southern California, it's a long way from Newtown, Connecticut. But boy, it's really tough to hear, because my son, who's 7 years old, is at first grade right now, and so I kind of wonder what's going on over there, what the teachers know, and it's just kind of unsettling wherever you are. Yeah.
Well, and then, how do you discuss this kind of thing with your children after the fact? And I know that at the schools now, they have drills for this. When you and I were little, Evan, we used to, at least here in California, we have earthquake drills all the time. And from time to time, something they would call a civil defense drill, whatever that was supposed to be protecting you from. Now they have actual drills, to keep the kids in the classroom and to guard against this kind of thing, to protect kids if this kind of thing happens at their school. So apparently it's becoming a common enough event that, the schools themselves are prepping for it, which is just an awful statement in itself. But right. We're going to let the actual news organizations handle that story and let you guys look to them for your information on that. We will stick to what we know, which is technology and the law. And with Bryce on the show today, the business side of all of that too. Bryce, why don't you tell us a bit about Invent and what you guys do there?
Invent is a publicly traded technology incubator in Santa Monica. We build web and mobile technology products. We work at the very earliest stages with entrepreneurs to develop their ideas, and then we put the first amount of capital in to seed that idea, and then we basically do everything necessary while the entrepreneur is building their product to build a successful company around that product. We started about, 2 years ago. And the thing that really sets Invent apart from other technology incubators is the fact that we are registered with the SEC. We are publicly trading, publicly reporting. So anyone and everyone that wants an opportunity to invest in early stage web or mobile technology products now has an option through a publicly traded equity.
Yeah, that's a really interesting model. Does that mean that the people who are buying stock in Invent are investing in your companies, or is there some separation there?
Absolutely. So, Invent is structured as a business development company, or it's a specialized type of investment company. So really the value that our company has is based upon our portfolio of companies. And so basically when you invest in Invent, you're really making an investment in each one of our individual portfolio companies. So, for an example, we have 6 companies in our portfolio right now. So if you invest in us, you have ownership in all 6 of those portfolio companies indirectly through our company. So basically, it's just it's a way for investors to have more of a diversified exposure to the startup industry.
Yeah, that's fascinating. Do you raise other funding as well?
Absolutely. So we raise, the money that actually comes directly to Invent is raised usually through private offerings. Now, you can also trade our stock, on the stock market, but of course that money is going back and forth between individual investors. But we raise money on the fund level for Invent, but then we also assist our portfolio companies in raising additional capital as well.
Mm-hmm. So you'll find different investors for the different companies that you have.
Absolutely. So, our first priority is to raise money for Invent to make sure that we have the money necessary to continue to build these companies to begin with. But then once we've begun to build the companies, we then assist those companies in finding additional capital, either from angel investors or from local VCs, really whoever's interested.
And do you have a particular focus for the kinds of companies that you incubate, or are you just looking around for anything that looks like it has potential?
I mean, specifically web and mobile technology companies. We definitely have a consumer internet focus. We're not against looking at many different kinds of ideas as long as they're within like the web or mobile markets. But most of the stuff we do is consumer based, is not like B2B or enterprise. Mostly like digital media, social networking, and location based mobile. We kind of, that's what we know, and that's those are the type of businesses that, given the amount of capital that we can provide, are the businesses that we can do the most with. So while we'll operate widely within those sectors, those are two sectors that we adhere to exclusively.
Okay, so with that in mind, let's talk a bit about the Jobs Act, because that's certainly something near and dear to tech companies in startup mode. The Jobs Act itself is in startup mode. It's not quite ready for prime time. The SEC is still deciding how to make sure that it's implemented in a way that's going to help both companies and make sure that investors are sufficiently protected. Have you been paying attention to this, Bryce, since last April when it first was approved? And how do you think it's going to affect what you do?
We've been paying really close attention to it. I still wonder how long it's going to take for the SEC to kind of make a final ruling on when they're going to implement the rules. It seemed like Mary Shapiro, at the end of her run as chairman, really didn't want to touch this issue, because at the end of the day, when the Jobs Act is incorporated, you're going to have more relaxed regulation in terms of how companies can raise money. So naturally, you're going to have some investor protection stripped, and that always opens up the opportunity for potential fraud in the market. And so, I mean, given that. I can see why Chairman Shapiro, before she went out, didn't want to implement that and have that be, her legacy. I can see where the new chairman, is hesitant to go forward with it as well. But, I think that, they will get it done hopefully here soon. I'm very interested to see what kind of additional limitations they try to put in place. Really, there's several parts of the Jobs Act, and there's really only a couple that are, still being, debated, in the SEC, and that's really, how to go about the general solicitation, and allowing companies to advertise, like private companies to advertise publicly for investment, and then also the crowdfunding portals and how those will work. And really, those things have overlap, but they both have their own separate issues that you have to work out as well.
Let's talk about what's going on with that. We've got Elise Walter taking over as chairman of the SEC in a few days, and them trying to take this act out of startup mode. Evan, do you think that they're going to be able to do this in an expeditious manner? And how do you feel, follow-up question, how do you feel about the investor protections that will be in place?
Well, it's hard to say how quickly this is going to go. With the transition, I think that's going to slow it down more than what would have been expected, and it's taken too long, the way it is right now. As far as the investor protections go, I think that there's plenty that's built into the act, and we should see it as a positive thing that it is taking so long, so that these things don't have a chance to get swept under the rug, and so that there truly is the right balance, because it is kind of a fundamental paradigm shift when all of this happens, the way that investments occur. So it's good. There's the silver lining of the amount of deliberate activity that's going on here. As frustrating as it may be, that's something that is positive, even though it's behind schedule. So it's good that there's some delay in this respect.
Mm-hmm.
I agree.
Bryce, once this is approved and all the rules are in place, all the operational components are there, how's it going to affect you and what you do?
It's going to be really beneficial to us. I mean, first of all, it will make it easier for us to help our portfolio companies raise money. It will allow them to, offer investment in their companies to a much broader audience of people. It will allow them to do it in a much more public fashion. So it should actually help us a lot in our ability to raise the initial seed capital for our portfolio companies. We're very we're interested to see how it goes with the companies that list on the crowdfunding portals. We're interested to see, what will be like necessary disclosure items for those portals. But, that's also something that should be a big benefit for our portfolio companies too. In terms of some of the other things that the Jobs Act covers, increasing the shareholder limit from basically right now there's a shareholder rule where if your company has 500 shareholders, then you have to register with the SEC. And, that's been somewhat prohibitive for some companies to, some companies don't want to go public for a while. And so, they've done all kinds of things to avoid going over that 500 shareholder rule. And, it's kind of an undue burden and expense. So they've taken that from 500 to 2,000, which, we're really happy about. It gives companies additional, room and flexibility. Also, there's a Regulation A offering that's basically an expedited offering for companies to raise money. And right now there's a limit to those offerings of $5 million. The Jobs Act will increase that from $5 million to $50 million, which, is also very nice. So it allows for larger raises with less disclosure, which, and is still an adequate amount of disclosure, just not having to deal with all of the things you would on a full like S1 registration statement. And then, above and beyond that, the other thing is, if you've got the crowdfunding, you've got the expanded shareholder base, and then the other big thing is smaller companies that do want to file with the SEC or emerging growth companies, they now are not going to be subjected to some of the regulation and disclosure items that bigger companies do, mainly Sarbanes-Oxley. As of right now, new issuers have a 2-year window to qualify with the SEC with Sarbanes-Oxley, and now we'll get a 5-year window. So, overall, it makes it easier to raise money. It makes it easier to advertise to investors. It makes it easier to expand your shareholder base. It makes it easier to initially list as a public company. So, for us, everything is an advantage, and we're supportive of all of this, and we're just very anxious to see, what the final rulings are going to be.
Yep, so are we. It's certainly been something we've been following ever since it first rolled out. There seem to be a lot of skeptics out there about whether this is going to be a good thing for, mom and pop investor and whether, as you mentioned, Bryce, the inevitable fraudsters will have a field day with it. But, nobody can really tell that at this juncture. And I think that probably the benefits are going to outweigh the burdens as long as, people are informed about it. So I'm glad that we're talking about it today. And, there are so many requirements on companies to make disclosures in certain ways. Certainly, they're taking that into account with the Jobs Act and trying to make sure that even while easing up required disclosures, that those disclosures still get made. There was an interesting story this week about Reed Hastings and Netflix that's probably near and dear to your heart, Bryce, because I have the feeling you, as the CEO of a public company, probably interact quite frequently on social media with people who are interested in your company and the things happening to it. What happened to Reed Hastings is this was on his own Facebook page where he has subscribers now that Facebook has that feature. And, the way I think about that is when you're posting on Facebook after this change to having subscribers, it's just like posting to a blog or to Twitter. If you post something with the public setting turned on and you have subscribers, those subscribers are going to see what you've posted. So it's a very public forum. And he dropped in a post, like a status update, that Netflix monthly viewing had exceeded 1 billion hours for the first time ever in June. He posted that on July 3rd. So the SEC is kind of up in arms in this because they have a couple of complaints about it that Netflix disagrees with. They think that is a material disclosure that has to be made in a truly public fashion and that Facebook doesn't meet that requirement. Let's see. What else is the SEC's problem? I think that pretty much covers it. I don't know what the other, the second part of what I had in mind was. If anyone else can think of it, chime in with it. But Reed Hastings disagrees, doesn't think it was. He thinks it was both public and non-material. So that he's just fine in posting that way on Facebook. And my immediate reaction was, oh boy, this can't be the first time this kind of thing has happened. I think it's probably the first time in a company this large, the SEC has gotten involved and said, I got to do this differently. Bryce, are you rethinking your Facebook posts?
I'm always very careful with what I post on my Facebook, for our Facebook and then for the company's Facebook and social media outlets too. I mean, the issue of fair disclosure and disclosing material information to everyone at the same time is an issue that all public companies have to take very seriously. And it's something that kind of causes us to walk on eggshells a lot as executives of public companies because, you're always wondering, if you're disclosing, if you might be disclosing something that you shouldn't, or something that you're saying maybe could be considered public information, or not public, but material information. So, but with what Reed Hastings did with Netflix, whether or not it was material or not, I don't think is a big issue. I think the bigger issue here is using social platforms as a forum to disseminate public information to the general investment community. And, Reg FD is basically the law that kind of governs this, and it's a 12-year-old law, and maybe it needs to be, or regulation needs to be updated. But I think the SEC's big problem with Reed Hastings in this case wasn't the fact that he was using his Netflix or his Facebook page as a way to disseminate information. It was the fact that he hadn't in any way on his website or anywhere else notified his investors in the investment community that he was going to use his Facebook page as a medium to disseminate information. I think if he would have I think if their investor relations page would have included a link to his Facebook page saying that, you can get updates about the company, follow Reed Hastings on Facebook, then I don't think the SEC would have had a problem, because there's other companies that actually do use social platforms right now to disseminate information, but they just do a really good job on their corporate websites of disclosing the fact that, please follow us here, here, and here, because we disseminate information in these places.
Well, can you actually, if you're not a Facebook member, this is a moving target as to what can be seen in Facebook making things more and more public. I'm going to facebook.com/Reed Hastings. Actually, this isn't a good test because I'm logged into Facebook on another tab. But my question is, if you have no Facebook account, if you're just, a member of Joe Public, non-social media user, can you access this site? I'm able to get to it, but as I said, I'm logged in. Evan, can you try it?
Well,
Facebook.com/. Right, you're not a Facebook user, so
right. I'm able to go to facebook.com/Netflix. Do you think that's where it was posted? I'm just doing a page search for billion. Where was it supposed to be?
I think it was on Reed Hastings' personal page.
Wonder if that's just facebook.com/Reed Hastings.
It is.
So,
does that come up for you?
It's asking me if this is the wrong Reed Hastings. I think this is him. I don't know.
I don't think that's him.
That's not him.
Yes, this is the wrong Reed Hastings.
That's confusing.
Yes, let me try again. Well, I mean, I think the point is, actually, this is kind of interesting. It's not there. So, that underscores the point, and I'm with Bryce that truly is the larger issue here, larger than the question of whether this was a material disclosure or a piece of material information that needed to be disclosed in the first place. And I guess the SEC is probably doing the right thing by first of all, we got to keep in perspective, they didn't really do anything. They just sent what's called a Wells notice, which is not any kind of formal legal action. It's not even a cease and desist order or anything like that. It's just that, you probably should have done something differently here, kind of just a warning shot, really, or just kind of a very gentle type of warning that Netflix didn't do the right thing here. So, I think it might be the right decision because it's not necessarily that there was anything that was harmful to anyone in this particular situation, but we want the SEC to be consistent in the way that it does interpret and enforce these rules or these guidelines or whatever it is that's relevant here, so that we don't slide into situations where there are secret communications, so that the import of the rule, it's not all that difficult to make this information available through other means. And it's also not safe to assume that just because there may have been some journalists who subscribe to this particular Facebook account, or who are who track the information that comes from that particular Facebook account, we can't really rely on that in all situations, so that, like I say, we don't want to slide into a situation where there's going to be some kind of secret communications here. So I don't see anything wrong with the SEC being uptight about this, because there are other more accepted channels for these types of communications, which ensure that in every instance, again, I want to stress that I don't think that anybody was hiding anything in this instance, but so that we ensure that in all instances the information truly is public when it is material and rises to that level. So this is, it's kind of intriguing, but in the overall scheme of things, I don't think it's all that big of a deal.
It actually, there is some significance of it for especially companies like Invent, companies like mine, like the micro cap public companies of the world, and or just in general, like companies that are traded over the counter that aren't on an exchange. I mean, there's like 15,000 plus, public companies in the U.S., but over 10,000 of them are very small OTC companies in nature. And when you're making these disclosures of public information, you're either filing an 8K, but most time people are filing press releases, through some distribution source. And these press releases cost $400 or $500 per release. A lot of companies are releasing a few press releases a month, and of course those bills can add up, especially for a small company. And companies do it because they feel like they have to do it. But at the same time, these press releases get released, they get buried. Nobody really looks at them anyway if you're a small company. So, it's actually a lot of times much more effective for companies to, do straight releases to a social network. Or a lot of times what you see is a company will do a press release and then they'll post it on their different social networks and post it on their website, and far more people see it on the social networks than they actually do from the distribution source. So, if we can get some more definitive rules from the SEC about what you can and can't do on social mediums, it would really help small companies a lot, because if we could avoid paying $400 or $500 per press release and just issue directly to social mediums and to our website, to where at least in one of those formats, even if you're not a member of one form or the other, you can find it somewhere. If we can do that and avoid having the expense of like a press release distribution, that would be really, really beneficial to a lot of people.
Right. And I think it's also beneficial to the investing public in a way, because when you're getting everything through a press release, that's very filtered and edited and scripted and carefully prepared. You're going to get maybe more spontaneous conversational kinds of information directly from an executive, then that may well be a lot more informative. Evan, the Facebook page is Facebook.com/read1960. Can you see if you can pull that up? Not being logged in.
I like how I can be the, is it just read 1960?
Read 1960. Because my question is, is this public to everyone? And if it is, then I really like Bryce's suggestion.
No, it's not. I can't.
You can't get to
access. That. No,
okay.
I just see him and I see his, like his profile pic and. Gosh, I feel like such a Luddite right now. What's that big banner?
No, it's good. It's good we have this test case because Alex in the studio is pulling up the page, but of course he's logged on.
Right.
So it's nice that
no,
we're
I'm not. This is
you're
not logged in.
Oh, you're not logged in. Well, Evan's not logged in either, and you can't see it.
I see it. I see his. I see his. Can I send you my screen in Skype here?
I don't know.
I don't know. I'm sure there are ways that I could. I just see the. What I could do is do a screen capture while we're talking about these things.
When you scroll down, do you see his December 6th entry talking about this?
No, I don't see anything on his. That's all I see. What you're seeing.
Oh, and neither does Alex.
There.
I can see in the studio. Alex doesn't have it either. You have to be logged in to Facebook to see. And this is a public post, his December 6th post, which is not showing up when either of you access it not logged in. So public does not mean actually public unless you're a Facebook member. So
that's an interesting question. So if you have a link, if on your investor relations page on your company website, if you have a link to a profile page for Reed Hastings, and someone could click on it and it would take you to Facebook, and if you hadn't signed up, it would prompt you to sign up. Since it doesn't cost money to sign up, there's no wall between you and signing up. Would that not be good enough in your all's opinion?
It wouldn't in mine. I'm with the SEC on that one. If it's not on a page that anyone can access publicly, like a Twitter page you can access publicly without being a Twitter member. I believe. Sure. Isn't that right?
Unless it's locked. The user can set to lock the Twitter account down. But
right.
I mean, that seems to be the essential issue here, whether it truly is public or whether it's public. I mean, and it's kind of funny to see how in a different legal context, putting it on Facebook, even with just a couple of your friends being able to see it, would truly be public. In as much as you wouldn't have an expectation of privacy in that content, say, for example, in a Fourth Amendment search, or whether the other side in litigation was going to be able to take discovery from you. So it's interesting how the rule of law will lead the courts or the fact finders or whatever, the regulators, to come to different conclusions depending on what the context is. Because, this is not public, even though 200,000 people saw it. In a different context, it could be public just because 2 people saw it. So
right. It flips our traditional Facebook discussion on its head. We're constantly on the show harping on the theme of anything that you post to Facebook is public. Consider it out there. But in this particular context, it's not public enough. So
it's goofy.
Kind of fun. All right. Well, let's move on. Another big story this week is in the copyright arena. Jammie Thomas, of course, has been litigating her case for quite some time. And the latest in her legal proceedings, you'll recall that although she had some relief from a huge file sharing verdict against her, that was appealed. And on appeal, the court decided that one of the 2 jury verdicts against her was going to stand, and it was the $222,000 jury verdict in the second trial, I believe it was. So she has taken that issue up to the Supreme Court of the United States by filing a petition for certiorari. Certiorari? I don't know that I've ever had the pronunciation of that right, and I'm an appellate lawyer, so that's just plain sad.
I always thought it was more like a Ferrari, so there you go, for what that's worth.
who knows what's going to happen with that? It is a very long shot, but it does give the Supreme Court the opportunity to take up the issue of whether statutory damages under the Copyright Act can be unconstitutional when applied in this way. So it's a big question. The Supreme Court did not take up one of these cases when presented with it last year, but they're going to be asked to do so again. So we'll just have to see if we can get them to bite. It certainly would be nice to get some consideration of this issue because, we've had lots of guests on the show that have big problems with the way that the copyright law operates in this context, and if lots of proposals for copyright reform where we've talked about it operating more like a parking ticket or a traffic violation as opposed to, a $222,000 jury verdict for downloading 24 songs. So, Evan, what do you think? 1 in 100 cases gets up to the Supreme Court. Give me the over-under here. What do you think?
I have no idea I think it's certainly less likely than not that it won't get there. Sorry for that double negative.
That was good.
I have no idea what I just said. It's probably not going to get there. Why didn't I just say it simply here? So,
yes.
But yeah, I would definitely. I think. I have lost track of how this analysis is supposed to go. This constitutional analysis. I know that when I read the Eighth Circuit opinion, it kind of made sense. For them not finding the statutory damages award in this situation unconstitutional because there's this whole argument didn't seem to fit in this particular factual context with the statutory damages. And so, but at the same time, I can't help but get behind the sentiment that heavy statutory damages awards are not good in serving the ends of copyright law as we like to understand them, at least from an abstract fundamental constitutional level, namely to promote the progress of the useful arts and sciences and all that stuff. Because what it does is invites trollish behavior. And I think it's very easy to analogize it. You were kind of introducing the analogy of a parking ticket. It's easy to analogize it to the war on drugs, particularly with marijuana. Especially in states like Colorado now, having less than an ounce of weed is pretty much like a parking ticket. I know that there's some nuances with all the interaction with federal law and all that stuff, but it seems to be like copyright law should be treated a lot like the way that the for lack of a better word, the normalization of marijuana laws have been treated over the years, where the punishments of sending somebody to jail for a year or more for just a small amount of marijuana, that's way out of proportion to the harm to society or even to the harm to the individual who's done that. And so that's why the loosening of the making more lenient marijuana laws are a good thing. Very same thing should be going on with copyright here. And it's these types of situations that illustrate how woefully out of proportion the damages awards are to the actual harm suffered by the plaintiff in these situations that should raise public consciousness about this and hopefully provide the animus for meaningful copyright reform. I think that's how change is going to be had here through the legislature in revisiting the circumstances and the prerequisites for an award of statutory damages in situations like this.
Yeah. Hey, before we get too much further with the show, I'm going to go ahead and drop in our first MCLE passphrase for this episode of This Week in Law, and it's going to be statutory damages in honor of the petition pending to the Supreme Court. Bryce, do any of your incubated companies, you're in Los Angeles, do any of them deal with media in a way that having rights owners come after them for copyright infringement is a big concern?
Nothing in our current portfolio, really.
No.
Thankfully.
So, yeah. But certainly for anybody who deals with startups in the entertainment field, and is concerned about perhaps liability, indirect liability for infringements of their users. This is something that would be a concern. Let's go on and look at. Yeah, let's go on and look at another big case that has broad entertainment industry ramifications. So also has been pending for quite some time. The Viacom versus YouTube case has had a new development recently, and that is once again YouTube and Google are seeking to have the case thrown out in the trial court, as they successfully did the first time. Then it went up on appeal and got sent back down. So now they're trying again. Unfortunately, we haven't had a chance to look at the, I think it's a motion for summary judgment. Isn't that right, Evan?
Yeah, it's the second time around filing a motion for summary judgment.
But it's been filed under seal, presumably because there's some confidential information in there that needs to be redacted before they make it public. So no one quite knows what arguments are being asserted at this point. However, over at The Hollywood Reporter, Eric Gardner pointed out that there is a publicly accessible 1,373-page filing that accompanies the motion that is showing each and every video that's at issue in the case in column form, with the video listed in one column, and in the other column, Viacom's evidence showing YouTube's knowledge that the clip infringed, and all those second columns are empty. So this is supposed to be, a graphic demonstration that there is no evidence to support the claims against YouTube and Google. So interesting. We'll have to see if they get a twofer on this, Evan. What do you think?
Well, yeah. I mean, I think they will get a twofer. I think the DMCA is on their side ultimately on this, but. With Google doing this as a litigation tactic, it's not for me to armchair quarterback their litigation strategy and all this. But ever since I was a brand new lawyer, having been practicing for like 6 months, and I remember filing a document with the court where I was trying to be cute. All I was answering. Maybe I've talked about this on the show before, but I remember answering an allegation in a complaint once by saying I had no metaphysical insight into the brain of the plaintiff, something like what I said, just to really dramatically deny or to say that I lacked information and therefore deny the allegation. Doing stuff like this, especially when you're going to cause some poor law clerk in the federal court to have to print out 1,400 pages of paper is probably, certainly, pushing the edge on what's a good litigation strategy here, just to, illustrate the point that they ain't got no evidence. This whole right column is open. So, like I said, far be it from me to be an armchair quarterback on Google's litigation strategy. They have brilliant lawyers helping them out on this, but that's just kind of one of those things. Like, is that really how we want to make that point in this summary judgment motion?
Yes. If I were inclined to submit such a table, I think I would have, put on the cover page, put one page of the table and a note at the bottom saying we could go on for 1,400 pages, but we won't.
Right.
Bryce, have you been following the Viacom case at all? Do you have any horse in this race?
I'm interested to see what happens. I don't really have a horse in the race per se.
Yeah. Yep, I think like all of us. And it's so funny because the case is so old at this point. All of the videos in question, it's just such old news, and YouTube has put in such measures that this isn't so much an issue anymore. Although, I think if you went to various entertainment entities, they would tell you that despite their various partnerships and things, there's still a lot of infringing material on YouTube that causes them concern. So the question here, as YouTube continues to litigate and defend itself, is how much specific knowledge it needs to have before it's responsible for pulling down something that is infringing. And hopefully the case will resolve that question for YouTube and others in its situation.
And I think the longer that the case goes on, and I think this was probably a point we were making 2 years ago and talking about the same case then it was only a 3-year-old case, is, with the more content that's uploaded to YouTube and, the increasing rate at which content is uploaded is just going to continue to make more apparent how ridiculous it would be for the rule to be that a platform like YouTube has to affirmatively screen every bit of content. I mean, it's just staggering now. That number keeps going up of the number of years of content that are uploaded to YouTube every month. And it would, take just literally thousands and thousands of people reviewing that content. It'd just be an impossible task to review everything. So that's shifting it, making it even more solidified all the time that the provider, the intermediary layer here, has to have these strong protections of the DMCA.
Right. All right, let's get on to some privacy stories. Evan, your favorite dude, Hunter Moore, is in the news again. We've talked about Is Anyone Up on the show a couple of times, and that site has been down for a while. Just to bring anyone up to speed who isn't familiar with Is Anyone Up, it is kind of this renegade site where folks could either submit their own or submit photos of other people in various states of undress. And those photos would be linked up with their Facebook account. So, whereas before you might just see someone's unclothed torso, you would then know, oh, that's Reed Hastings 1960, for example, on Facebook.
Come on. Think of a better example than that.
And as far as I know, Reed Hastings has never appeared on Is Anyone Up?
Never sent a selfie.
Yeah, never sent a selfie. Yeah, that's a fun line from this article over at Cash Hill's site, discussing what Hunter Moore's latest plans are. Why don't you tell us, Evan, what he's gonna do? He says.
Well, Hunter Moore, what a character! I mean, he's such a lightning rod, for controversy, because he's, not only does he set up these controversial sites, but he goes out into the media and just says these outrageous things like the most recent iteration here is that the site is going to have enhanced features where geolocation information might be included, or, a person's home address would be included here. And he says, yeah, we're going to do this so that people can stalk people. And then, a little while later, he says, I didn't really mean that. I was just really incredibly drunk during that interview. So, even though Hunter Moore, the things he says and does, appear to be really obnoxious, there's just something about him, kind of like Tucker Max. Remember Tucker Max? He's kind of maybe not as popular as what he was. Who I'm talking about, Bryce?
Yeah, I do. Absolutely.
Yeah, I mean, it's just these characters that are just like, so out there and so outrageous and so maniacal, and have these egos that are 10,000 times more either strong or weak, I don't know which one it is, than the average person. And so there's just something that's just this hugely entertaining about him. So when it comes to this most recent thing that Hunter Moore is talking about doing here, including people's home addresses with these photos here, I think it changes the nature and the character of our discussion about it a little bit, because always in the past we can't talk about Hunter Moore and Is Anyone Up without talking about the immunity from liability for the website under Section 230, that portion of the Communications Decency Act that says that the website can't be treated as the publisher of third-party content. Because everybody says, go after Hunter Moore for infliction of emotional distress, invasion of privacy, and all that stuff, and we've just got to
copyright infringement.
Well, copyright infringement is a little bit different, because I think he should have been complying with the DMCA. And he really hasn't. So to the extent that people own the copyright in the photos they take of themselves, I think that since there's never been a good mechanism for the DMCA takedown procedures, he could be pretty, have some liability for secondary infringement there. But I'm sure when the new site launches, since he's getting all this funding that he's talking about, he will have hired good lawyers to advise him on DMCA takedown mechanisms and all that stuff. So, but what really makes this a little bit different is, those outrageous statements like I was referencing there. It's like, we're going to let people add home addresses so that people can stalk people. If that indeed is true, and if indeed what he's saying kind of a little bit later is that, really we're not going to do that. We're only going to do that if there are people that I don't like, or if they're taking legal action against me. That's only when I'm going to do that. He's running into an area where Section 230 doesn't provide as good of a protection, because there is an exception to 230 immunity. And that's kind of a weird concept to get your mind around. But if you kind of break it down, Section 230 says that you as a website operator are protected for most of the crazy stuff that your users do, but that protection does not apply to you. You're not protected for any federal criminal activity that you undertake as a website operator. So, say, for example, if he was knowingly engaged in some kind of criminal activity across state lines or something like that, it's kind of difficult to actually pinpoint what the federal criminal liability would be here. I don't, there's like the Mann Act and all that stuff we could probably talk about, but this kind of stuff, when he's starting to really become an aider and abetter of criminal activity, that's really starting to erode away at Section 230 immunity. So it'll be interesting to see what Hunter does here. He's obviously intelligent. Whether or not he makes great decisions is another question, but certainly a charismatic character, and it'll be really interesting to see what he decides to do here. If there's going to be anybody out there pushing the limits of these types of legal doctrines and legal theories, it's going to be Hunter Moore, and giving us all something to read about and Cash Hill to write about now until we see what happens with this next go around. Just one final point on this: people get really upset at Hunter Moore for providing this platform, and I think that a lot of times that outrage is well directed because of the way he may encourage people to do this, but he's not really providing anybody with any tools that aren't available to any web user. Really, you could go start a Tumblr account and dox someone, or post pictures of them, or
that's what
whatever.
He's done, right? With his site down, he's doing it on Tumblr.
He did that.
Yeah, and and he was, and I think on Twitter some as well. Mm-hmm. But anybody could do that about anyone, if they have that information. So what we really got to keep in mind here is that the primary liability has got to lie with the ex-boyfriends and, to a lesser extent, ex-girlfriends who are disclosing this information and content about people in the first place. That's really where the tort is being committed here. So, it's easy. It's fun to go after Hunter Moore. He's a character. He needs a new publicity shot. I've only seen that one picture of him. So, Hunter, get that updated. But at the same time, the real legal stuff, the discussion, the meaningful legal discussion, and the real thing where the law can help people is in figuring out who the individuals are who's doing this and seeking redress against them.
Yeah, my follow-up comment to your commentary there, Evan, is it's just as hard to get your head around the fact that his protection comes from the Communications Decency Act, that as it is that there's an exception to that act.
Yeah,
Bryce, is it hard to get your head around as a person who helps startup companies and helps get them funding, the fact that Hunter Moore has raised $150,000 to get his site back up and running and bigger and better than ever?
No, I imagine that Hunter Moore could raise much more than $150,000 if he wanted to or if he needed to. One thing that is interesting is that of the people that he's raised money from, nobody wanted to be disclosed. So they're all private investors. Nobody wanted their name attached to it. And that happens a lot. I mean, we see deals at Invent all the time that we really like as a potential investment opportunity, but for one reason or another, they're just kind of in that gray area of, is this cool? Is this not cool? Are we, stepping on people's toes here? Is this offensive to someone? And, we tend to try to kind of stay away from those investments. It's not to say that they're not good investments or they wouldn't, provide a good payback. I don't know what Hunter Moore plans to do to monetize his site other than advertising, but I would assume that from advertising alone that, he could provide his investors a pretty good return.
I think he said he sells 15 T-shirts an hour, so there you go.
Well, and that's good. The thing about what he's doing. I mean, this new thing about whether or not he's going to include people's addresses or allow people to be able to be geolocated. That's great to stir up controversy. That's great to get yourself back into the media. There's no reason they should actually do it, though. Like, why risk it? Why put yourself out there? Why not just take advantage of it? Take advantage of the increased media attention. You'll get more traffic to your site, and you'll sell more T-shirts, and you make more money. And I think at the end of the day, it's good business for him to stir up controversy because that gets page views, and that brings in more money for him.
Well, I just certainly hope that, at this stage of events and technology that's out there, you need someone like a Hunter Moore and his, whatever the motivations of his users are for submitting these photos to be able to link up, X torso with Y Facebook profile. But let's just hope that, facial recognition is the only thing that's in development as far as being able to match up photos of people with their identities,
it's did we talk about this a couple weeks ago? Because I know Naughty America has already launched a platform that's still, pretty crude. Or, a friend told me that it's pretty crude. I didn't. So yeah, that's there. That's the next thing that's coming here, being able to upload a picture and find, where that person has appeared online in other photos of different genres.
Yeah, different genres. That's a generous way of putting it. I just, getting to what you were saying a second ago, Evan, and playing devil's advocate for a minute here about Hunter Moore, aside from the fact that, it takes humans now to link this stuff up, he's really just being an aggregator, right? It's the link that's the difficult part, the part that feels not right. Yeah. He's basically just bringing together publicly available information and linking it to somebody's identity. So it's hard to say that there could be a lot of liability attached to aggregating information that's publicly out there, but it's the anonymity destruction that is problematic here.
Yeah, and I think probably the most unfortunate thing about all this, we can't look past the fact that the site like isanyoneup.com is very harmful to reputations. It shatters emotional lives of people. I've helped people who've appeared on the site, and I know firsthand from helping them that it's a terrible thing to be featured on the site. Section 230 protection appears in most instances pretty strong for Hunter Moore in these things. I think that there are some areas out there in the periphery under the teaching of the roommates.com case where he falls out, and certainly with the criminal stuff. But I think the biggest tragedy of this all for the larger social sake is the fact that when stories like Hunter Moore is doing make it into the mainstream. He's been on Anderson Cooper, and when it actually starts, when people start becoming aware of it, and when members of Congress start getting aware of it, they're going to perhaps want to revisit Section 230 and undo such protections that are critical, vital to the internet infrastructure. And that will be really unfortunate to see bad facts like "Is Anyone Up?" result in bad law, bad legislative actions that would undo what this very critical piece of legislation.
All right. Well, in a minute, I want to get to talking about public attitudes toward being tracked, speaking of destruction of anonymity. But we're here with Bryce Knight from Invent and Evan Brown from the Info Law Group and me, and we're talking about the latest and greatest in the world of technology law. And one of the reasons we're able to do that is through the help of ShareFile by Citrix. You know, everyone in business has had to deal with emailing a file that was too big to attach, sending confidential files without a secure way to do it, needing to access a document while on the go. Well, I have the answer to all of these problems, and it's ShareFile by Citrix. It's the all-in-one business solution for sending, sharing, and receiving files of almost any size. ShareFile was designed for business and can be customized to meet your company's specific needs. Every file stays under your control, so you know it's secure. You can manage who has access and for how long. You can see what files are opened and by whom. Plus, ShareFile allows you to access files from any computer or any mobile device, so it's just an added bonus that you have cloud access to all this material that you otherwise might have to be sitting in your office to get to. For me, it's a great tool for my solo law practice. It means that I don't have to go out and commission someone to set up a secure client extranet. I can just use ShareFile to share any document, any large presentation or large media file that otherwise I might be concerned about actually getting there if I sent it by email. And the customization tools mean that I can make that landing page for my clients look exactly how I want it to. It has a consistent professional feel with the rest of my business presence, which is really important. It will benefit anyone working in the legal or any other profession. I really want you to try it today. You can sign up with my special offer. You get a full 30-day free trial. To do that, you go to sharefile.com, click on the radio microphone that you see there, and enter TWiL, T-W-I-L. Remember, visit sharefile.com and type in TWiL. Thank you so much, ShareFile, for your support of This Week in Law. Okay, so we've got this great article over here in Ad Exchanger. I picked this up off the Project VRM list and thought it was really interesting. It's a survey of consumers that said that yes, they're definitely concerned about being tracked, don't like companies following them around the web and monitoring their activities, but they're becoming more and more comfortable with it as they grasp that, you know, as long as they are dealing with trustworthy parties and they're getting some value out of the tracking, this might just be an okay arrangement. Hunter, dealing in the consumer space with mobile kind of companies, I'm sure that this is an issue that's near and dear to you and your incubated company's hearts, you know, how to maintain a trust relationship with customers and still be able to gather the data from them that enables you both to monetize and to provide them with a rich experience. Is that right?
Absolutely. I mean, what we found is that consumers don't want to be tracked. They don't want to be followed unless they're being provided with some relevant value. Like they will give up. Like consumers are happy to give up some privacy if they know that in return they're going to get something of value back, and that privacy will be protected by the source that they're giving it up to. What we found, especially with one of our portfolio companies that's a content distribution platform, basically an advertising platform, is that that whether you're using data to target or using data to retarget, or however you're tracking potential users, at the end of the day, everyone's much better off, and the advertising is more effective, and the users are much happier if it's relevant quality content that they're getting and not just spam advertisements. So, I mean, what we found is that as long as what you're giving the consumer is of relevance to them and could be of value to them, then they're willing to, give up a lot of their data and information to you, as long as, again, you protect that.
Right. I liked this quote from the article talking about trust. Let me find it right here. Here we go. Consumers trust that if they give up a bit of privacy, the company will provide something of value in return. If they do, the company can gain a loyal customer, but if they don't, the customers will opt out or go elsewhere. So, that hope that trust would be a market force seems to be becoming a reality according to this Accenture Interactive study talked about in this article. And if you're interested in reading this article and everything else that we've been talking about today, you can go to delicious.com/thisweekinlaw/191, and our discussion points are all listed there. Evan, did you check this out, and do you think that does this change your approach toward do not track or anything else related to it?
Well, no, I don't think it changes my attitude toward that. I mean, but what I do think is that this goes to a really key fundamental idea when it comes to the online economy and how content is made available by platforms in return for the providing ads on its on those platforms' inventory. And so it's the trust key is something that I think is pretty self-evident, and it's good to see that the science seems to bear that out, because without that, this whole ecosystem would break down. We will never see a day where social media and other platforms, mobile interactivity, all that stuff is going to be as robust as what it is today if it becomes a pure subscription model for every opportunity to interact online, whether that be to communicate with someone else on a social media platform or share content or comment or do anything like that, which is the converse of saying if we want to have the web and the mobile environment be the way it is now, we're going to have to get used to it being ad-supported like this. So it's good to see that the science bears out the importance of trust, because that's what's going to be the real marketplace influencer here. Those platforms who can execute in a way that consumer trust is gained and kept. And when end users continue to have a good experience where their interactivity is pleasant, and they enjoy being on social media platforms and being served relevant advertisements that will allow them to actually be presented with opportunities to learn about products that they actually want, and for it not to have a negative consequence. That's what we need more of, so that the money keeps flowing into the system, and we continue to see advancements and new opportunities for fun, entertaining, and revenue-generating things to do online.
Bryce, what's your approach to do not track, your attitude toward that and that issue, and also toward the various privacy proposals that have been in Washington lately in response to consumers saying, hey, we don't like all this tracking?
Yeah, I think that consumers should have the ability to, have as much control as possible over, not being tracked and opting out of being tracked. So, at the end of the day, if people are trying to get out of something, or people are trying to avoid something, then it's not going to be that successful or that effective anyway. At least not for the things that we're doing. So. If consumers want to, or people want to be able to not be tracked, I think they should definitely be able to do that.
All right. Let's see. We've got a couple of other fun stories here. Before we move on, let's go ahead and make trust our second MCLE passphrase for this episode of This Week in Law. And I want to give a shout out to our intern from last summer, Franklin Graves, who I think has his last law school final for the semester today. So good luck, Franklin, and to all the rest of you law students out there who are in the throes of final exams right before the holidays. I remember that time. It was not very fun. Let's talk about Bitcoin, Evan. Thinking that we might not ever talk about Bitcoin again. I forget exactly what the prediction that you made on the show was, but that it might have been about a year ago, and that we wouldn't be talking about Bitcoin in a year. So let's just go ahead and talk about it.
No, you're just doing that because I said that. You found this obscure article about some insignificant thing happening in France. So
yes,
fine.
Exactly. Don't belittle it because it's in France. I thought it was entertaining and interesting. The point is that Bitcoin has apparently, I won't pretend to be able to understand all the information about French banking laws. But the notion is that Bitcoin has been given the go-ahead to basically function as a bank under French law. And my immediate thought was, okay, so are they going to print cheap calendars and be closed on Sundays? What does it mean to function as a bank? But apparently it gives it some kind of legitimacy. It gives it access to their equivalent of FDIC deposit insurance, which is a good thing, I suppose, for people using Bitcoin. This doesn't legitimize or make you think that Bitcoin is the currency of the future, or at least a legitimate currency?
Absolutely not, because it's not accomplishing all the great things that the proponents of Bitcoin say that it's supposed to do. The most salient thing among those lists is being independent of any governmental system. Why are the Bitcoin proponents celebrating? Because a government decided to back it up. I mean, isn't that exactly what we're trying to, or what the Bitcoin people are trying to avoid here? Maybe I'm missing something. I likely am, because Bitcoin's not all that impressive to me, but I just don't see how this is any indication of its validity if what we're saying is a good development here is that a government decided to ensure its legitimacy and also provide a system where people can actually use real government-issued money to get Bitcoins and do things with it. I just don't get it. I don't see how that's any different than just saying that 4 monopoly dollars are going to represent a dollar, and I can go to, we can go to our pretend store here and buy stuff, but when it comes at the end of the day, if our system fails here, we've got the government to back us up. Where's the innovation?
Yeah, I see what you're saying. Bryce, do any of your companies have any plans to accept Bitcoin payments or Bitcoin funding in the future?
Well, not anytime soon. Not anytime soon. Bitcoin is not on the product roadmap right now for anything in the portfolio. Regarding what's going on with Bitcoin, though, I generally agree with Evan on his points that I don't see how this could be considered a win for Bitcoin. I am interested to see, as Bitcoin does become more mainstream, just how the individual central banks of the different Western European countries and then the central bank of the U.S., publicly comments about Bitcoin and what they have to say. I would assume that they would be highly critical.
Yeah, I keep bringing it onto the show, Evan, not just because it's funny little back and forth between you and I, but I am interested in the future of currency, and as things become more and more electronic, I think that if not Bitcoin, then something like it will gain some traction and trust and be an alternative to our traditional banking structure. We might be a long way from that, but it's not too hard to envision, do you think?
I don't know why anybody would really want to do that. I just don't get it at a real fundamental level. I mean, I am fine with. I'm not with Ron Paul on this. I'm fine with at least in principle. It's not being executed perfectly, but with kind of an international monetary system where the civilized governments of the world can agree on how our money should work. I think that's a good thing. I think that's an indicia of an advanced, evolved society that leads to peaceful coexistence among people and among nations. So I don't understand I'll just go ahead and call it kind of an anarchist tendency to try to undercut that system through a currency value exchange that is outside of, at least by definition, outside of that system. I'm all about electronic innovation. I'm all about enhancements in security. I'm all about enhancements that in appropriate circumstances would allow people to transact anonymously, which is supposed to be all the good things about Bitcoin. I just don't understand why we would want to go around this robust system that has so much benefit and so much good and stability that it contributes to our world and our global economy. Why we would need to circumvent that in the first place?
I don't know that we do. It's just, having little kids, or a little kid in my case, makes you, when you have to explain the way the world works to them, explaining money is not that easy. Why is this piece of paper worth anything to anybody? And you have to go through and do a whole history and economic lesson to get to the right answer. So open sourcing money is something that strikes me at least as interesting and something that's fun to pay attention to. We'll have to, again, keep an eye on Bitcoin and see if we're talking about them in a year, Evan. One thing I know we've been talking about for a long time is whether or not they were ever going to change the FAA rules that prohibit you from using things like your iPad. I think cell phones are just right out of there. They don't want those signals monkeying around with the plain avionics. But things like your Kindle or reading on your iPad, that kind of thing, or even just listening to music on an old-fashioned MP3 player, those things have been prohibited during takeoff and landing. And the FCC chairman has now taken issue with that and is trying to convince the FAA that they should consider lifting their ban on those kinds of devices in flight. So we may be moving closer to more device-friendly flights soon. I have a friend who's a pilot for American Airlines, and I know he's been using his iPad in the cockpit for quite some time. They keep all their flight plans and things on those devices and use them. I surely hope he's using it during takeoff and landing. Any thoughts on this, Bryce?
Is there any proven issues that these things actually do affect the planes in any way, or is that just what we've been told through the years so we don't use these things?
I think that
sure.
It's been inconclusive, which is, erring on the side of caution. They can't conclusively say it doesn't affect. So, and I don't know. I mean, there may be studies out there that say otherwise, that say, yes, it's perfectly safe and there's some other agenda at work here, but I am not.
I think cell phones are a bad move just because, you have cell phones and there's inevitably going to be people talking, through the flight and be very distracting. But in terms of like the other electronic devices, as long as they don't have any effect on the plane itself, then I don't see a problem with it.
All right. Evan, you think we're going to make some headway on this?
I think somebody just needs to do a science and figure out whether there's really anything going on, and then there we have it. It shouldn't be
the sarcastic rover.
That's right. We should,
bring it home for the holidays.
It might be tough to make it home by then, but this should just purely be a scientific issue, and put it behind. If it's under a certain threshold of risk, then let anybody use a tablet. It's gonna stimulate the economy, right? To be doing more work on your tablet while you're in the air.
Yes, indeed. All right. Well, let's talk a bit about patents. Kaboom! All right. Well, just to there have been some very, very disturbing developments in the world today, and just to sort of lighten things up a little, I wanted to roll this YouTube video about what Apple's been up to.
From the very beginning, everything we've done has been designed to be very capable, but also remarkably familiar. So our goal was to take all the amazing things that people like to do and own them. Once our lawyers successfully patented the page turn, we realized there was so much more we could claim. So we went back to the legal team, and they came up with a patented system of 26 unique characters that you can use to express almost any word in the English language. We call them letters. With letters, people no longer need to communicate with objects, images, or grunts. They can use whole words. Sure, we could have stopped at just 10 letters, but then we thought, why do that? Why not go all the way to 26? You'll be amazed at what we can do with letters. With Apple's new letters, we can write the words cease and desist And we can copy those words in courts in almost every state in the union. Seeing your words and sentences
So
in
it was
Apple's
first
new
the
letters
page
makes
turn.
it seem like you're that much closer to
Now
owning
letters.
something that you thought was yours all along.
The other entertaining thing about that video is the woman who came in and was trying to show what communications were like without letters. She looks an awful lot like Esther Dyson, although I doubt that it was actually Esther. This is that was by Ron Charles, who is a book critic for the Washington Post, I believe. So he actually has some very entertaining stuff up on YouTube, and that's one of them. So lead into talking about Apple and its various patents. There have been some developments in the Apple versus Samsung litigation. A whole flurry of things went before Judge Koh this last week, who just wants them to all get along. The primary issues have been taking issue with the enormous damages awarded in Apple's favor and putting forth various reasons why those should be reduced. Specifically, Kathleen Sullivan at Quinn Emanuel, former dean of Stanford Law School. That's got to carry some weight when Stanford's former dean is arguing on behalf of Samsung that the damages are too high. But I don't know that it's going to do any good, at least at this stage. Also, there's this strange kind of trying to undo the whole jury verdict because one of the jurors had a relationship, had been opposite Seagate in litigation a decade ago. And Seagate is a partner of Samsung's. And he was the jury foreman and apparently quite influential in the jury's discussions and providing a lot of information for them on the difficult issues in the case. So Samsung is arguing that because of his former hostility toward a company that is aligned with Samsung, that he had it in for them. Again, no news on whether that's going to get anywhere or not, but all of this was heard before Judge Koh. Evan, do you think any of this post-trial stuff is going to change anything before the case goes up on appeal?
I don't think so. I mean, I think things were pretty thorough at the trial. I think what's more likely than anything drastic happening on appeal is there's some kind of resolution. But you know what? I don't watch this nearly as closely as what at least 9,000 other people do who are commenting on it every day. So when it comes to how it's actually going to turn out, I don't know. The most interesting point that I saw was there was all this talk about that jury foreman leading up to that hearing, and it turns out that they actually talked for 2 hours about damages, and then it got, there was just like a couple minutes at the end where they actually talked about that guy. So I don't think that's nearly as big of an issue in the parties' minds as what the media and the press covering it was going to be. I mean, it looks like there was plenty of opportunity for the Samsung lawyers to ferret out those issues. The litigation with Seagate was actually about 20 years ago. It was in 1993. So that just seems to be such an issue that doesn't bear out, and then there had been plenty of opportunities to do it. So I guess the thing that I can kind of say with certainty, or at least how it looks to me, is that's not going to be the catalyst for any big change in the situation between the parties here. And then finally, I guess the other point about this that I wanted to make was, isn't it interesting? This is not something that's just about patent litigation, but it's about any complex litigation with well-funded parties going after each other. What happened to the finality of a verdict? And the reason I'm asking that is, one of the stories was talking about Judge Koh saying at the end of the hearing, when are we going to see when is this case going to resolve? She was looking for global peace. It's like, well, wait, there's a jury verdict, for crying out loud. Isn't that resolution? Well, of course not, because there's so much at stake. There's so many resources available to be put behind this dispute with the inevitable appeals if it goes that way and doesn't settle. So a verdict, a finding of fact by a jury of one's peers is essentially has no indicator of finality at all in certain circumstances. And I thought that was kind of an interesting thing about this.
Another little interesting footnote, not in the Apple versus Samsung litigation in California, but in the ITC proceedings with Apple, Qualcomm had a funny, strange thing happen where it filed this letter against Apple on various FRAND questions before the ITC, just really taking shots at Apple. Qualcomm makes the baseband chips built into all wireless Apple devices, starting with the iPhone 4S and the 4G iPad. I'm reading now over at Florian Muller's site. So it filed this letter. People were going, what is going on here? Qualcomm filing against one of its biggest customers. The letter itself was very full of rhetorical vitriol and just a really strange letter. Well, it turns out it later withdrew the letter and asked the ITC not to give it any consideration, arguing that it had been filed by a law firm without appropriate authorization. So, oh my goodness, somebody really messed that one up.
That's like that Republican study committee about saying good things about copyright reform. I guess you got to be careful, make sure everybody's really authorized to speak on these things.
Right. It's just a good lesson for lawyers that, you may be working on something for a client, but you better be darn sure they're ready to pull the trigger before it gets filed. Let's talk about, here's an interesting thing that happened over at the FTC. There was a meeting, a conference, I don't know what we want to call this, hearing, a gathering, they call it over at Ars Technica, where representatives of intellectual ventures and other patent trolls and their critics showed up and had sort of an educational discussion with the FTC, which is trying to get itself up to speed on the whole question of patent trolling. And one of the people that was there, let me get her name correct, Colleen Chien, if I'm saying that properly, has been analyzing the patent lawsuits filed in 2012 and the ones filed in prior years as well, to track how many of them are actually being filed by non-practicing entities or patent trolls. And her report reveals that 61% of all the patent lawsuits filed here in the first 11 months of 2012 were from patent trolls. So it's certainly a thing. It's certainly on the rise, too, because in prior years, let's see, this comes to us from Mike Masnick. In 2011, it was 45%. And 5 years ago, it was just 23%. So it's certainly a trend on the rise. Is this something that causes you concern, Bryce, for your companies? And how do they approach their own patent issues?
It definitely is a concern for us. I mean, we do consumer internet products, and these are type of products that are iterated so quickly, and there's so much competition that usually we're not usually concerned about trying to file patent protection. We're concerned about getting to where we're going first, because there's just so much overlap now with the platforms that software companies build on, and features that are used, that it has generally been our view, at least with the size of our companies and the resources of our companies, that trying to go down the path of getting patent protection it just hasn't been worth the while for us so far. In terms of patent trolls in general, at least from the view of startup technology companies, they definitely get in the way of innovation. They definitely scare people away from doing certain things, because at the end of the day, the litigation can get so expensive related to patent matters that unless you have substantial resources going into it, no matter what side you're on, it can end up being a pretty devastating event for an early stage company. And that's if you're being accused of infringing upon someone's patent, or if you're just trying to protect your patent from someone else, it's still, a long court battle. It's still a lot of money, and it still drains a lot of resources. And, that's always a bad thing for, companies that are, trying to make it on a shoestring budget and, bootleg as much as they can. And there's not that many resources. And when you have limited resources, you like as little of those as possible to go towards litigation matters.
Yeah, there is a great quote from Peter Detkin from Intellectual Ventures from this gathering at the FTC. This is in Joe Mullen's article over at Ars Technica. Detkin is, though, poo-pooing the whole issue that intellectual ventures or those like it might be quelling innovation. He says this is a solution in search of a problem. The idea that tech companies couldn't avoid intellectual ventures patents isn't really true, because it would cost, and insert here the word only, $80,000 to analyze our entire portfolio. I think people could figure it out if they really wanted to. So, build that into your next funding structure, right, for one of your companies, the $80,000 ticket to analyze intellectual ventures portfolio. Evan, what do you think?
The problem
sorry, go ahead, Bryce.
I'm sorry. One of the big problems is that especially it's become like a patent war between the big guys in technology, where each one of the big companies, the Googles, the Yahoos, the Amazons, the Facebooks, they're all buying up these patent portfolios and trying to get as much protection for the technology that they have and as much protection against being sued, that it's really a bunch of defensive moves on behalf of the big companies. They're spending tons of money to do it, but they're trying to protect themselves from each other. But at the end of the day, it has a serious effect on the smaller companies too, because if you think that there is a possibility that someone might try to litigate you for some kind of patent infringement, just a very small chance can get you to completely rethink whether or not this is something that you want to put a lot of money towards or not.
Yeah, absolutely. Evan, do you think it's helpful that the FTC is educating itself about patent trolls?
Definitely. I think that we all can be well served by educating ourselves about this, because this is by no means a simple issue, even though it's very polarizing and people get behind a certain position and they go all out on that position as if it's black or white. It is by no means so clear cut what the issues and the various interests are at stake here. And so for that very reason alone, it's good that there's education going on. And along those lines, I think Joe Mullen's piece on Ars Technica from December 11th, that is one of the pieces that that we're discussing here, is really good, and everybody should read it, because it does a great job in a very relatively short period of time, in a short space here, kind of lay out the various interests that are at stake here. Off the top, I think it's also interesting that the FTC, I guess it was the FTC in these discussions, came up with a third, or at least a third term to refer to these folks here, patent assertion entities, or PAEs. We call them patent trolls, we call them non-practicing entities, and then there's also now patent assertion entities, another name. That seems to be like the softest kind of name for them here.
Although phonetically it does amount to pay, which is what you wind up doing with a patent assertion entity. You pay it.
Isn't that interesting? It is. So we've got to figure out whether that's the way we want to keep it, or whether that's something that we need to change. And so, on balance, I come out on the side against being sympathetic toward non-practicing entities. I see what their arguments are. I just don't think well, there are two ways that I don't think that it pans out to be the right thing to be supporting the interests of these PAEs, non-practicing entities, trolls, whatever you want to call them. One of the big motifs of that side of the equation is that what the patent trolls do in their litigation, I'm just going to stick with trolls, it's easy. What they do is ultimately get money to the inventors. And if we're going to start from the point that invention is good, innovation is good, then, and we just stop right there in the analysis inquiring as to what is good, well then fine. The more litigation that there is over these things and the more redistribution of wealth that there is so that it gets to the inventors is a good thing. But that's not, that whole premise is not the right way to start from, and therefore the analysis breaks down and one sees that the patent troll perspective is not the right way, because if we look, and this is the second time I'm bringing it up in this conversation, the patent and copyright clause of the Constitution, if we look at really what is important and what the drafters of the Constitution, and this is just based on good policy, it's to promote the progress of the sciences, promote the progress of all of the arts and sciences. And mere invention and putting it in a document that you file with the patent office is not what is going to promote the progress ultimately. What's going to promote the progress ultimately is getting it out there in the marketplace, using it, and being rewarded for that use, not just for having thought of it. So those entities who are just inventing and putting it down on paper, I would go so far as to say, are not entitled just by that to think, oh, these millions of dollars now have to start rolling onto me. The rewards should be given for those who are not only innovative and who are inventive in that respect, but who also have the business acumen and the motive to put themselves in a capitalistic society and actually make it happen so that the progress truly is done. So if that's the starting point for what is good, then there's no reason to think that the ultimate benefit should go to these folks who are not actually out there practicing the art. And so clearly, like I said, it's anything but black and white. There's a lot of gray issues in here, gray space, for these issues to be resolved. But I think that the appropriate starting point is to make sure that we're not thinking of it just protection for having invented, but protection for having invented and actually put it into place, making something happening, promoting the progress. That's where the protection and the benefits, the monetary benefits should inure.
All right, from your mouth to the FTC's ears, hopefully. Let's move on and give you our resource and tip of the week. Our resource, both of them have sort of a holiday theme to them. I don't know. The Wii U is, I think, still a hot holiday item, although there have been some complaints about its functionality and launch. I bought one, so it replaced our original Wii. But over at TechDirt, Mike Masnick has a good article on the DRM infrastructure of the Wii U. He's actually aggregated a bunch of information and posts by, for example, Kyle Orland over at Ars Technica and Chris Kohler, talking about Nintendo's move into having a cloud service, sort of, and internet access. And basically, tries to bundle together all of the roadblocks you're going to face as a Wii owner as you migrate over you try to migrate over the games that you've downloaded before, and how the anti-copyright violation steps that Nintendo has taken has made that very difficult, and how the terms of service make it, and also just the way that the Wii functions, impossible to use a Nintendo network account on any other console. So it basically is penalizing users all in the service of copyright protection. It's a good article, and if you're going to buy a Wii U or you already have purchased one, it's a good thing to check out to know what you're getting yourself into as far as restrictions on your ability to use the device and things that you may download to the device. So that is our resource of the week. And our tip of the week, also with sort of a holiday theme, is from David Spark. David's been on our show before, and he's a former way back tech TV person. He used to box with Patrick Norton, if anyone remembers that far back. on one of the shows. Anyway, he does lots of social media communication stuff these days. He writes something called the Spark Minute, which is full of good tips and tricks. And he has a post called The Best and Worst Business Pickup Lines. So although this relates mostly to attending conferences such as the one where I encountered Bryce recently up at On Hollywood, I think it would have good play for holiday parties and gatherings as well in the business context. He starts out with his best business pickup lines, how he likes to approach people and establish a relationship with them that he doesn't know, and then the worst ones. And I love that he absolutely lambasts people who walk up to you who you don't know them and they ask, "How can I help you?" Which always grates on me when that kind of thing happens. And also people at conferences who just start giving out their business cards willy-nilly before they even have any kind of relationship with the people that they're encountering. So great advice from David Spark. Go check it out so that you don't socially mismanage your holiday gatherings. And with that, I think we're going to go ahead and wrap up this episode of This Week in Law. It's been great chatting with you, Bryce, and following up from On Hollywood. You were great there, by the way. Really loved your panel there.
Thank you very much. I appreciate it. Thank you for having me.
It's been a pleasure, and thank you for making it through with your cold. I hope you're feeling better very soon.
Thank you. I'm hanging in there.
Good. Where can people find you off the show other than at Invent? Where should they follow you on Twitter and all that?
My Twitter handle is BryceKnight1, so they can follow me there. Or you can follow me on my LinkedIn page, which is also LinkedIn in extension Bryce Knight.
Yes. And I thought it was interesting, too. We didn't talk about this on the show, but you're a former sports bar owner. So you bring that to play in your dealings with new companies.
Oh, yeah, absolutely. I unfortunately, I don't have it anymore as kind of like a home base to bring people back for meetings. But, honestly, the sports bar business is a great business, but it wasn't that profitable of one for me. So I'm glad that I did it, but I'm glad that it's in the past.
All right. Well, we wish you all the luck with Invent and your companies there. It's very interesting, too, that that is a public company. So if you're looking for a way to invest in startups while the Jobs Act is still pending, go check out Invent, and that may be the way to do it. Thanks a lot, Bryce.
Thank you very much.
Evan, it's been great chatting with you, as always. And now Evan is mute and miming goodbye at us. I don't know, somehow we dropped his audio. But I'm sure that he is.
There it is. There it is.
There you are. You're back.
Yeah, I did something that disabled my trackpad. I have no idea what I did, but I had to grab the mouse over there on the desk. So having bandwidth issues and all kinds of stuff at the last minute, but somehow we'll pull it out. So, but yeah. Thanks for having me. Bryce, it was great talking with you. Really interesting stuff what you've got going on over there. So really enjoyed our conversation. It was a lot of fun.
Yes, it was. And Evan, I feel for you. My magic mouse likes to decide to take a hiatus in the middle of the show. Oftentimes, I have to keep AA batteries, close at hand in case I need to swap them in.
Yeah, so ghost in the machine sometimes.
Yes, exactly. Well, we're glad that we've made it through this episode of This Week in Law and that you've made it through with us. You can join us every Friday at 11 o'clock Pacific time, 1900 UTC this time of year, when we record the show live at twit.tv. And if you can't make it then, you can find us on iTunes and on YouTube. You can watch us on your Roku box and various other places that you like to consume your video cast content. Pontent. That's a new one. We're thrilled that you find us whenever and however you do. Between the shows, you can find us at, we have a Google Plus page for This Week in Law, or you can just check out my page there. Much like Reed Hastings, I just sort of speak magnanimously on behalf of the show. And also over on Facebook, we've got the This Week in Law page there where we try and work with stories during the week that are of interest to you. So send those on into us and we'll try and incorporate them into the show. We love to hear what you thought about our previous discussions as well. And if you're not so public with wanting to make those comments, please feel free to shoot us an email. Evan is evan@twit.tv. I'm Denise at twit.tv. And we love hearing from you there too. So until next time, we will now sign off of This Week in Law. Take care.